you want to move forward with that offer we discussed? If I can have your signature? It's 9/19/24. Okay, and I'm going to announce the terms from the judge. Thank you, Your Honor. My client will be entering a no contest plea as charged. Count 1 will be a withhold of adjudication, 1 year standard probation. It's $40 per month cost supervision, $615 in court costs, $150 in defense costs. There's a substance abuse evaluation and any recommended treatment, 24 hours community service, no alcohol, no drugs without a valid prescription. There's the random urinalysis, random breath test, gainful employment, or 3 job applications per week. There's the automatic termination of probation at 6 months if all costs and conditions are satisfied and there are no violations. Count 2 would be adjudication of guilt and credit for time served. If I may approach the assigned plea.
Yes, sir. Thank you. Thank you, sir. Mr. Sedovi, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. You can put your hand down. Mr. Sedovi, did you read the plea agreement?
I did.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes.
Are you satisfied with his representation?
I think that, oh, yes, absolutely.
Okay.
I think it's a good deal.
Okay.
I thought I was expecting way worse, so I'm really appreciative.
Good. Did you sign the plea agreement?
Yes.
Okay. Mr. Sedovi, I do accept your plea. Adjudication is withheld in count 1. You're adjudicated guilty in count 2. Count 2, you're sentenced to credit for time served. Count 1, you're sentenced to 1 year of probation. However, that supervision will automatically terminate at the 6-month mark if you've successfully completed all the terms of your supervision and haven't committed any new law violations. You'll need to pay the $40 per month cost of supervision, court cost, $150 public defender's fee. You will need to submit to a substance abuse evaluation within 30 days from today. Begin any treatment if it's recommended within 60 days from today. Perform 24 hours of community service work. Have no alcohol or drugs, no medications without a valid prescription. Submit to random urinalysis, random breath test. You'll need to maintain gainful employment or perform 3 job applications per week. Thank you, sir. Good luck to you.
All right, thank you, sir.
Yes, sir.
Take those copies.
Terry Price is here.
Great, thank you.
Mr. Price?
Hello, Mr. Price. Please. Mr. Price, do you want me to appoint an attorney if you qualify financially? Or do you
Yes,
intend
I
to
will
hire a
need-
private attorney?
I will need time to get an attorney.
Okay.
Yes, sir.
Mr. Price, did they hand you the information?
Yes, sir.
Good. So that's the charging document. That's what the state is accusing you of, violating those crimes of fraud, swindle, obtaining property under $20,000, and then larceny. So I do enter a denial for you and set your case for November 12th at 9 o'clock. If you're going to hire a private attorney, do that sooner than later so that they can start working on your case and communicate with the state. If you decide not to hire a private attorney, you can fill out a financial affidavit at the clerk's office for the public defender.
Oh,
Okay?
yes, sir.
So I'll see you November 12th at 9.
Thank you.
Thank you, sir.
Judge Kevin Sanders, the fugitive injustice case with the state. Knows anything about that?
Okay, on Sanchez. So 24 CF 1867, a capias will be issued for Mr. Sanchez, and it'll be a no vote.
Usually the state dismisses the FFJs once they've been proven to be picked up or transported?
Has he been
It
picked
appears
up?
that he has been picked up. He was booked in the jail on the 8th of August and released on the 5th of September.
Okay, so 24 CF 1867 is dismissed.
Same with
Brendan Speakman.
Brendan Speakman.
Okay, on that case,
Let me catch up with you there.
it's number 15 on the docket.
He, Mr. Speakman was booked on the 19th of August and released on the 18th of this month, so yesterday. So. he was
So you're
picked up.
dismissing it?
Yes, sir.
24 CF 1975 is dismissed.
Brian Williams is the same.
And that was a quick turnaround. He was booked on the 16th of August and released on the 21st of August. So we would dismiss that one.
That case is dismissed. Okay, Madam Clerk, so
I have
who's left?
Antoine Ridge.
Yes, Antoine Ridge, 24 CF 1892. KP is issued
I
for,
would ask you not to do that. I believe
Okay.
that we were working out a global pleads. He has a case in a different division. And this is the one that Steve Medina, and
Oh, yes.
give an update on, he was entering the plea in that court, is that right? Or are we gonna put it in
Correct.
ours?
In this case, I'm not appointed though, so, but I know what you're talking about.
do you want to continue this to the next arraignment?
Yes, sir.
Okay, let's do that.
Okay.
Even though I'm not appointed, but I got it.
Okay.
Okay, Madam Clerk.
Randy Williams Jr.
Bridge.
Randy Lee Williams, Jr. Okay, anything going on with that case from the state? Or
No,
what are
sir.
you seeking?
We'd asked KPS for his restaurant.
KP is issued for Mr. Williams. That means that they'll arrest him and put him in jail, and the first appearance judge will determine the bond.
And then I have Daniel Tingle, who is an inmate. If y'all are ready.
JJ, can we have Tingle?
Hello, Mr. Tingle.
Mr. Tingle is present before the court in 24 CF 1435. May I have 1 moment, Judge?
Certainly.
And Judge, may I approach with the state?
Yes, sir.
They receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Mr. Tinkle, everybody's working together. There's just one more thing the state needs to do. Hopefully that'll be done tomorrow or this afternoon. If not, then the court will be available every day next week electronically, okay? Good.
Procedurally, this was set on an arraignment docket, and we would enter a plea of not guilty to a one-count information, waive its formal reading. I would ask for this to remain on the November 12th docket, but as the court has been informed, we are trying to resolve this with a misdemeanor plea in absentia, which we're going to try to make happen much sooner than that November court date, probably in a matter of days.
Good. Thank you, Mr. Tinkle.
That's all for 1:30, but I do have some left over for 9, if you want to go ahead and
Okay. Do we want to do anything from the, are we ready for anything on the 2:30 yet?
Your Honor, I have two bond motions. One of them, I'm waiting on some witnesses to show up, but one doesn't. No witnesses.
Okay, do you want to do that one now?
Sure.
I am.
Can we do Tipton first? He's from the 9 o'clock, right?
Certainly.
Great.
Okay.
Judge, Mr. Tipton was on the 9 o'clock docket. We reviewed the score sheet as we received and discussed yesterday with the state. It was set plea or continue for today. I'm going to request a continuance until the November 12th docket. However, this is likely something we're going to see on the next available miscellaneous docket for an early plea.
Okay. Mr. Tipton, I just wanted to make sure that you had all that information. So I'll see you no later than November 12th. Thank you, sir.
We're going to do Malcolm and Willis from the 2:30, because those are fine.
Okay, thank you. Good afternoon, sir.
How you doing, Your Honor?
Good, how are you?
Your Honor, this is Mr. Norvillis before the court. He has filed a motion to reduce his bond.
Yes, sir.
And I know the court's gone through the bond motion.
I have.
Really, it's a request to reduce one bond, the $90,000 cash or professional bond on the trafficking methamphetamine allegation. Mr. Norvillis, in complete candor, Your Honor, if he is bonding out, he is going to be living with his sister in Lake City. Again, that's all in the motion.
Yes, sir.
Leesburg. I'm sorry. Leesburg, which is in Lake County.
Lake County, yes, sir.
Over there somewhere. He has already been ordered to comply with pretrial services. So obviously, if the court does grant the motion, we would be requesting that that specific in-person requirement be switched to telephone reporting. This is a brand-new case. I don't even have discovery in the matter just yet. He's been in jail since late July. He certainly can't afford the bond, or I wouldn't be asking the court to reduce it. I'm not asking the court to touch any of the other bonds, just that $90,000. And we're asking the court to reduce that to a $10,000 cash or professional bond, which would still require Mr. Norvillis to post that, most likely with a bondsman, who hopefully would give the court some additional assurances that they'll make sure that Mr. Norvillis is back before the court when he needs to be.
Okay, thank you. To the state?
Okay.
Yes, Your Honor, the state is just respectfully requesting that these bond amounts remain in place. Reading the facts, Mr. Norvillis there was a traffic stop that attempted to occur on a vehicle because it was reported stolen. That vehicle was matched with the license plate number. When the lights and sirens went on, a chase ensued, and I believe Mr. Norvillis in the report said that he got up to around 91 miles an hour. From there, loses control of the vehicle and actually runs into a pole and then gets out and flees. They find him with the alleged narcotics, the alleged methamphetamine on his person, and I think the amount of the bond probably has something to do with the grams. There was approximately 90 grams of methamphetamine found, which is why I've never seen a $90,000 bond before. I thought that was interesting. Given this, the fact that the defendant attempted to flee on foot, attempted to flee in his car, and given the fact that this is a trafficking amount of methamphetamine, the state does feel as though that is a reasonable bond that has been set, and so we would respectfully request that that bond remain in place, Your Honor.
Thank you. Mr. Kleins?
I didn't see anything about 91 miles an hour in the reports that I have.
didn't either.
But I mean, it is what it is. I hate to say this, and I certainly don't mean, I don't want the court to take a dim view of Mr. Norvillis on this, but recently I have learned what the street value of an ounce of methamphetamine is, and it is shockingly low for the fact that it is considered trafficking. And I'm not trying to make that the basis of the argument here. It's kind of like pills. You know, back in the day, you could find yourself inadvertently having trafficking amounts of pills for having like 6 of them. And it's kind of like that with methamphetamine now. The street value of methamphetamine hovers between $100 and $150 an ounce. So it is what it is. These are allegations at this point only against Mr. Norvillis. And we're simply asking the court to reduce that one bond to something that he potentially could afford. I don't even know if he could afford it, but he certainly can't afford a total of $100,000 in bonds.
I understand. Mr. Norvillis, I did do my homework. I read through the motion, looked at both arrest reports. And like the state, I have concerns about those facts, and the court can only go on the very limited facts that I have right now. And based on that, your motion to reduce bond is denied. I believe it's reasonable. Well, I see Mr. Norvillis on November 12th.
You will, Your Honor.
Thank you, sir.
Yes, sir.
I'll come talk to you at the jail when I get this going.
Yes, sir.
Judge, I got a quick one. Number 6 on the 230 docket, Mr. John Reinhold on 2 cases. It's the 23 CF 1837 and the 24 CF 455 case.
On the 230 docket?
Yeah, should be number 6, Mr. John Reinhold.
I don't have
It was
Mr.
a last-minute add-on, Judge.
Okay, got it.
Oh, I'm sorry. Read it.
Got it, handwritten in, okay, got it. Yes, sir.
Do you have a motion the court to dismiss it with whatever paperwork you have?
I didn't bring any people.
I didn't bring it either.
Okay.
Good, how are you?
Yeah. Okay, so we're not, okay.
Follow what I'm saying?
I follow. Judge, I apologize, just to speed up the court. This was my client that had that pancreatic cancer. He did pass away. I provided proof of the obituary to Mr. Snell. I thought that was enough to no pros, but it's not. I guess a death certificate's needed. So
Okay.
if we could keep this on that 11-12 docket.
Yes, sir.
Thank you.
Anything else? 130.
Not the one thing.
Okay, we just want to know.
Okay.
I got
Okay, so you want to do the 9 o'clock?
Yeah,
How do you
I
want
would
to
like
do it?
to, I mean, just, Mr. McKinney only has one left, so that.
We have-
would-
Okay,
I don't
good.
know.
No issue.
Mr. McKinney only has 1 case left.
Yeah, it was Kelly Thorpe Jorgensen.
Ma'am,
Kelly Thorpe Jorgensen,
okay?
just the lady.
Is he out there?
He's on the phone.
Oh, okay,
He's coming to get it.
good. Mr. McKinney, the clerk's looking out for you and said you only have 1 more case.
I appreciate that. It'll be Kelly Thorpe Johnson, and we left it on as a status just to make sure that the PTI paperwork had cleared. She had been instructed by probation on the 16th, but I hadn't seen that paperwork clear yet. And as I checked this morning, I don't think it had cleared as of yet. But she's already been instructed for the PTI and already began her condition. So I'm unsure if we need to have another control date or not.
It's a new case, correct?
It is.
Then why don't we just keep it on for November 12th, and it'll fall off.
Yes, sir, and we're just waiting for the paperwork to catch up at this point.
Good, thank you.
And then from 9 o'clock, I also have Alyssa Pedersen with Mr. Koch.
Your Honor, unfortunately, Ms. Pedersen did not show up this morning.
Well, that's the one, I don't want to throw her under the bus. She's from California, so I don't want to automatically KPS with her. The issue that we're at right now, she's the one, Your Honor, if you recall, she hasn't paid a penny in restitution and got on and was like, oh, I can come up with $1,000 in 4 days. And then I was like, that doesn't track with me, because I know they make around $8,000 a month, the husband and wife together, and the fact that they haven't paid any restitution. So we appointed Mr. Koch just so that we could hopefully get the ball rolling, but from what I understand, she hasn't gotten into contact with him at all. I don't want to KPS her just because I think that's going to present issues with her being in California, but I do want to set it for one of the October dates, give Mr. Koch some time to speak with her about what amount of money she could maybe give in exchange for us ultimately dismissing the VOP and getting her off probation, but I need more than $1,000. So I just wanted Mr. Koch to know that, but I don't want to KPS her and then that just cause more issues for us. So if we could set it for the October date.
What date do you want? Late October?
Any of the October dates, yeah, just.
Why don't we do
10th.
October 21st?
That works with me, Your Honor.
21st, Judge?
Yes, sir, at 9?
And if I may ask, Mr. Gomez states she's in California. I have not spoken with this client at all. Is it okay if she appears virtually for that court date?
Yes, sir.
Okay, thank you. I'll do my best, Your Honor, to locate and inform her.
Good.
And then also from the 9 o'clock docket, I have Sean will do with defense attorney James Barnes. To set for a VOP and a status.
Okay, I just see the status conference. It's also set.
For a VOP.
Okay.
Checking my email to see if I've had any contact. Did you say Richard Barnes?
Yes.
Yes, sir.
I personally have not had any contact. If we want to set this on the very first date of October, I'd be okay with that.
Okay, October 10th at
Yes, Your
9
Honor. I'll
o'clock.
make sure to get up with Mr. Barnes in the meantime.
Thank you.
That's it from the 9/1 docket.
Okay. Any other defendants came in? I don't see that. So we just have 2:30 left, and we're not ready to go on any, yes, ma'am. You ready?
Good morning, good afternoon, Judge.
Yes, ma'am.
Your Honor, Brandon Powell on behalf of Jonathan Watson. We are set on the 2:30, but Your Honor did indicate you might be able to get us started a little early.
Yes, ma'am. Sure, if everybody's here.
The defense is ready to proceed.
Okay.
That be excused, Your Honor.
Yes, sir, thank you.
Just like a couple things with Scott, we should be fast.
Judge, because this is going to be, we anticipated it might be approximately an hour. I know
Yes,
I
ma'am.
mentioned to you that I do have a flight to catch. Did you want us to do it from
You
here?
can have
or
a seat
from
at the table if you want
Okay.
to. Yes, ma'am.
Just wanted to. whatever made
Sure.
more sense for you.
Yes, ma'am. Hello, Mr. Watson.
Hello, sir.
Okay, so we're here on the motion for new trial.
That is correct, Your Honor. Judge, I do have a witness in the courtroom. I didn't know if the state wanted to invoke the rule or if we could just proceed without doing that.
To the state.
Judge, I don't see my witnesses in the courtroom. I defer to defense on the matter.
Well, okay, are you ready to go forward? Do you think they'll,
I am, yes.
okay. So do you want to invoke the rule or not?
I would defer to defense's preference.
I don't really have a preference, Judge.
Okay, then I won't. If you're not invoking it, neither will the court. Yes, ma'am, Ms. Powell?
Thank you, Your Honor. Judge, we're here before you in the case State of Florida versus Jonathan Watson, case number 22 CF 483. The defense has filed in this matter, timely filed, a motion for new trial after the trial that was held at the end of July in this case. The motion was filed on August 5th of 2024. The basis of our request for a new trial, there are 4 bases contained within our motion. Judge, the first is that the verdict is contrary to the law or weight of the evidence, which is governed by Florida Rule of Criminal Procedure 3.600A, subsection 2. We did put in our motion a number of bases that we believe that the weight of the evidence does not support the jury verdict in this case. And I'm sure that Your Honor has read the motion.
I have, yes, ma'am, and I've highlighted different things.
Okay.
Yes, ma'am.
Well, Judge, then for purposes of the record, I'm not going to read into the record the case law that was cited in the motion. However, I would just point to a couple of issues that when Your Honor is being asked, or when a court is being asked to rule on the weight or sufficiency of the evidence, those are actually 2 distinct concepts. One is the sufficiency of the evidence, which is very much like the motion for judgment of acquittal. If you take all of the evidence in the light most favorable to the state, could it support a jury verdict? Whereas an analysis of the weight of the evidence rather goes to the credibility of witnesses and whether or not the weight of the evidence presented by the state is sufficient to support a verdict of guilty. In this case, we believe that it is not. And the reasons that we believe that the weight of the evidence in this case is insufficient to support the jury verdict is for a number of reasons. The first of which is, Your Honor, that the alleged victim in this case did indicate that numerous times she had lied to her parents, lied to the Watsons, that she told mistruths during the CPT investigation and interview. Your Honor, specifically, on the night of February 14th, she told her mother that she was going to dinner with the entire Watson family when she knew that she was going with just Mr. Watson himself. Additionally, she advised the CPT interviewer, Ms. Watkins, that after he dropped her off after dinner on the 14th of February 2022, that she didn't talk to him again. There were 690 pages of text messages that were introduced into evidence in this case, Judge. After the dinner on Valentine's Day, the alleged victim in this case actually initiated text conversations after dinner. And so that was another thing that she told during the course of this investigation that she clearly knew the seriousness of, that was not true. The state attempted to introduce to ask the victim, is it because you didn't actually speak to him, but just texted with him, and she explained away her answer by saying, yes, it was because we didn't speak, but they rarely spoke on the phone. She said that during cross-examination. And I'm sure if you talk to any teenager these days, if they say they're talking to somebody, they're probably texting somebody. So the court is allowed to use its common sense in evaluating the weight of the evidence and the credibility of the witnesses in this case. Additionally, in that 690 pages of text messages, regardless of the attempts by the state to cherry pick certain text messages that support their theory, the defense could do do we have a verdict? Is that
One second. I was just bringing up Zoom. There's Natalie Bowen is on Zoom. I don't know if she's for this hearing. Is that the one that wanted to attend?
That's one of the investigators we discussed
Okay.
later on, Judge.
Your Honor.
You let me know when you want me to bring her on. Okay? Yes, ma'am.
Thank you, Judge. So with respect to the 690 pages of text messages, there were just as many text messages from the defendant to the alleged victim in this case, encouraging her to be confident, to talk to boys that she liked, to go get a boyfriend, to go out on dates with boys. He was certainly encouraging her to do those things in the course of that 690 pages. And the defense admitted this during closing argument, certainly the context of some of those conversations seemed wildly inappropriate for somebody Mr. Watson's age and the alleged victim's age. However, there were 690 pages of text, and nowhere in those text messages was there any indication or admission of him perpetuating these acts upon the alleged victim. There were certainly references, as the state said in their response to our motion, references to talking about the other night and feeling guilty about it. But if you look at the context of those specific text messages that were pulled out by the state, you'll see that they were talking, that Mr. Watson and the alleged victim in this case were actually talking about a conversation that they had had. And he asked her, why does she feel guilty? And she said, I think I make myself feel guilty sometimes. And his answer to her was, why? Because you're happy? You shouldn't feel guilty for being happy. There was no mention of, I feel guilty because of what happened between us, other than talking about a conversation that they had. So looking at the weight of the credibility of the alleged victim's testimony, Your Honor, we believe that somebody who has told mistruths and admittedly lied during the course of the investigation in this case, that her testimony should carry less weight, and that Your Honor should look at that accordingly when making the analysis in this case as to whether or not the weight of the evidence supports the jury verdict. The third facts that we believe the court can look at to show that the weight of the evidence in this case does not support the jury verdict is that as to the events on February 12th that allegedly occurred on the couch of Mr. Watson's home, they just don't make sense. Common sense, listening to the alleged victim in this case, as well as the other testimony that his daughter was also asleep on the couch with them, that his wife was up and walking around the house, constantly in and out of that room, and that they were watching a movie and fell asleep. It doesn't make sense that they would both wake up at the same time and something like what the victim says happened would happen with so many other people around. And she said that that was the first time something like that happened. Your Honor, we're asking you to use your common sense in evaluating the veracity of those statements as well. Additionally, as I mentioned a few pages later in my motion, when asked on the stand which hand Mr. Watson used on February 12th and on February 14th to allegedly digitally penetrate her, she said she didn't remember. And that's just not believable based upon her recollection of the specific facts of how they were laying, how they were sitting in the truck on February 14th. Those things just don't seem believable. Your Honor, additionally, as to the truck on February 14th, we introduced pictures of the truck, the size of the truck. This is a big 1-ton pickup truck, Judge. It has a 14-inch center console. Additionally, the alleged victim stated that they were both sitting normal in the truck. Now, the state's argument that if they could hold hands and they could kiss, that certainly he could reach over and touch her in her vaginal area. That's not the same thing. If you're holding hands, you can hold hands over the center console. If you kiss, you can lean in and kiss over the center console. However, if you're sitting down in your seat, if you believe the alleged victim's testimony, she stated she was pulling away from the defendant at this time when he digitally penetrated her in the front seat of the truck. And that's just not possible over this 14-inch console in the cab of a truck that's over 5 feet wide. Judge, it just doesn't make sense, and it could not have happened the way that she is alleging that it did happen. So based upon that, Your Honor, we believe that the weight of the evidence regarding the penetration that's alleged to have occurred on February 14th is not enough to support the jury verdict in this case. She also stated that on February 14th that she asked Mr. Watson to stop because he was being so aggressive that she thought she would bleed. However, that's not consistent with the physical evidence in this case, or actually lack thereof. There was no evidence of any injuries, scratches, or bruises that would have occurred with such an aggressive action. I understand the state's position that the vagina is an organ that is designed to be penetrated, but that doesn't mean that somebody's fingernails wouldn't scratch or some hard pushing wouldn't leave bruises, and none of that was present in the CBT interview. And even if it wasn't introduced at trial, Judge. So none of that was present. So the lack of evidence in this case does not support the victim's version of the facts. Additionally, the only injuries that the state did introduce were pictures of bruises. There were conflicts in testimony about how and when those bruises occurred. And those bruises were from tickling. They weren't from any criminal act that was alleged to have occurred. Based upon that inconsistent testimony about when those bruises were caused and what caused them does not support the verdict in this case. She had indicated that he held her down and tickled her one night. Investigator Butler testified that those occurred when they were play fighting in the truck, but there's no testimony to support that and no evidence to support that. And even Ms. Watkins, during her cross-examination, admitted that the alleged victim in this case did not disclose anything to her during the CPT interview that would have led to those bruises occurring. So in the first interview that she was given at CPT, she did not explain the bruises, the ones that CPT took pictures of. So to come up with some excuses to how they got there later just is not conceivable. It's not credible, Judge. And so based upon that, we believe that the weight of the evidence does not support the verdict in this case for that reason as well. Additionally, Your Honor, the testimony regarding the DNA in this case, or actually lack of Mr. Watson's DNA in the crotch cutting of the underwear that was obtained from the victim. The testimony that was given in court by Investigator Butler was really designed solely to state that there was nothing of consequence, I think is what he said. There was no findings of consequence in the DNA report, but there were findings of consequence, Judge. And the findings of consequence were that Mr. Watson's DNA was completely excluded, that his DNA was nowhere in her underwear. However, there was other DNA, and that is a basis for an argument that we do later on down the line. But also, it doesn't make sense that if Mr. Watson was being as aggressive with the alleged victim on February 14th as she was saying he was, that there would be none of his DNA on her underwear. It's not consistent. Her testimony is not consistent with the physical evidence in this case. So Mr. Watson did take the stand during the trial, Your Honor, and we believe that his testimony shows that he was a credible witness, and for a number of reasons. One, he admitted to things on the stand that didn't show him in the best light, and he knew that going in, that is, and he did the same thing when he spoke to Investigator Butler at his house. The state introduced his initial interview with the police, where he came home as soon as he got a call from Investigator Butler that he needed to come home and have a conversation with him. So he came right home and had the conversation. Investigator Butler even said, he came right home. It was only about 15 minutes. He sat down on the couch. He said that he had kissed the alleged victim in this case. But when confronted with any other evidence that there was DNA, that, items that could be tested for DNA, and would he be willing to give his DNA, he said absolutely, without hesitation. So his actions on the date that he was arrested, as well as his testimony here in court, was not that of a guilty man. It was testimony of someone who was basically saying, I know I was wrong to kiss her, and I know we probably shouldn't have been having the conversations we had. But that's not enough to sustain a verdict of guilty in this case. Your Honor, it's our position that an analysis of the evidence introduced at trial, as outlined in my motion as well as my argument here today, that the weight of the evidence does not support a verdict of guilty in this case. The case law cited in my motion indicates that the weight of the evidence is really, it's like a preponderance of the evidence. Does the greater weight of the evidence in this case support a finding of guilty or not guilty? And we submit that an analysis taking into account the credibility of the witnesses, the inconsistencies between the testimony and the physical evidence in this case, and the inconsistencies between the witnesses that were put on by the state, all of those things could easily give rise to reasonable doubt, which tilts the scales in the favor of this verdict that was returned, a guilty verdict, was not supported by the weight of the evidence in this case. Judge, the second grounds upon which we are moving are contained in Florida Rule of Criminal Procedure 3.600 subsection B6 that provides that the court should grant a new trial if the substantial rights of the defendant were prejudiced because the court erred in the decision of any matter of law arising during the course of the trial. Your Honor, we sought to have the evidence that there was third-party DNA in the underwear of the alleged victim that she turned over, introduced at trial. The reason is because, as I stated during our motion in limine, is because that would have given her a motive to lie if she was covering for somebody else, if she had either been abused by somebody else or having consensual relations with somebody else. But the evidence of third-party DNA in her underwear would give her a motive to lie. And I know that I said during the motion in limine that invariably the state will stand up and say, she doesn't have a motive to lie. And that's exactly what happened on the state's rebuttal during closing argument. And the state's response to my motion indicates that there needed to be more, that we needed to give more in order for Your Honor to grant that request by us to have the DNA admitted. But I don't think that we do, Judge, and the reason why I don't think that we do is because the defense doesn't have to give the state every question that we might ask during trial. And if you remember, in this case, because of the new law, and I had to file a motion to take the victim's deposition, I had to give all of my questions to the state prior to taking the deposition with a reasonable follow-up. So I am not bound, the defense in this case, in any case, is not bound to the questions asked at deposition or theories that may have been developed during deposition. That's not the only thing we can introduce at trial, Judge, and our hands were tied. We were not able to fully develop its defense in this case. We were not able to fully show a motive for the alleged victim in this case to lie. And because of that reason, clearly his substantial rights were violated under the Sixth Amendment of the United States Constitution, the right to fully develop his defense, and that was denied in this case. For that reason, we believe that Your Honor needs to grant a new trial in this case. We have the opportunity to correct that here at the trial court as opposed to waiting for the appellate court. Your Honor, the state did rely upon Esteban versus State in their motion in limine argument. One thing that I did want to call to your attention was that in Lewis versus State, which is quoted in the Esteban case, where the defense claims that the victim has fabricated her testimony in order to preserve the victim's sexual relationship with a third person, courts have permitted the admission of such evidence. Additionally, in Lewis, that was in the Esteban court, but the Lewis court, the Florida Supreme Court says, we recognize the public policy underlying this rule, referring to the relevancy argument, the codification of what's known as the rape shield law, that a victim of a sexual assault should not be subjected to having her sexual history brought up in open court. But hold that where, as has occurred in this case, application of this rule interferes with the confrontation rights or otherwise precludes a defendant from presenting a full and fair defense, the rule must give way to the defendant's constitutional rights. Nothing could be clearer that his substantial rights were prejudiced by us not being allowed to explore that theory of defense during our cross-examination. Judge, we also have made an argument that according to Florida Rule of Criminal Procedure 3.600 subsection B7, that the court should grant a new trial if the substantial rights of the defendant were prejudiced because the court erroneously instructed the jury on a matter of law or refused to give a proper instruction requested by the defendant. Judge, this section of my motion talks about the jury questions in this case. And they did ask whether or not they could see the CPT interview. And we all as a group agreed that the instruction that the court gave was acceptable. And sometimes we don't think of things while they're happening. However, while I think that the instruction that the court gave to the jury was legally accurate, I think that adding language to it would have made it more accurate because there were parts of the CPT interview that were introduced by way of impeachment on cross-examination. And I'm not sure that the jury looked at those if they were also told that they were not allowed to see the CPT interview. So we don't know what weight the jury gave to those during their deliberations, during those questions that were elicited on cross-examination that clearly exposed prior inconsistent statements by the alleged victim in this case. And Judge, finally, on pursuant to Florida Rule of Criminal Procedure 3.600 subsection B8, the court should grant a new trial if the rights of the defendant were prejudiced, if the substantial rights of the defendant were prejudiced because due to any other cause not due to the defendant's own fault, the defendant did not receive a fair and impartial trial. Your Honor, in this case, we did invoke the rule of sequestration of the witnesses. The witnesses were outside of the courtroom, including Mrs. Watson, who took the stand during the defense in this case. And attached to my motion is an affidavit from Ms. Watson, and I will call her briefly to verify the facts that are in the affidavit. But I wanted to outline the argument for Your Honor. We had state witnesses that were outside of the courtroom, not speaking to one another, just sitting out there prior to coming in to testify. Officer Bowen, in this matter, was not speaking with Investigator Butler prior to his testimony. However, after he left the courtroom, he did walk out and have a conversation with Investigator Butler. So I understand these are law enforcement officers. A lot of people know one another. They probably have lots of things to talk about other than this trial. However, Judge, they weren't speaking about anything before they testified. Investigator Butler was still subject to his initial testimony in this case. And yet Officer Bowen walked outside and had a conversation, and Ms. Watson states in her affidavit clearly that she overheard him say, "They asked me." So certainly it gives the appearance of impropriety. It gives the appearance that the rule of sequestration was not abided by the state's witnesses. Additionally, Ms. Watkins, after her testimony, walked outside and had a conversation with Investigator Butler. And under these circumstances, Judge, it gives at the very least the appearance of impropriety when they're sitting outside, have nothing to talk about prior to taking the witness stand, and then as soon as someone comes off the witness stand, they go outside and have a conversation with another witness who was out there the whole time. So it certainly, at the very least, gives the appearance of impropriety. If the witnesses in this case conferred and discussed what their testimony was, what cross-examination questions were, did you know about this? This is what they asked me. Certainly that gives the witness an opportunity to prepare an answer or to make their testimony consistent with other witnesses' testimony, and robs the defendant from an opportunity to a meaningful cross-examination. And with that being said, Judge, we believe that that is also a basis for Your Honor to grant a new trial in this case. Judge, if I may, I'd just like to call Ms. Watson to the stand for a moment.
Ms. Watson, if you'll please come to the stand. Do you want me to bring on Ms. Bowen?
I don't think that's necessary. I'm just going to call him briefly myself. I don't think he needs to be part of this piece of the proceeding.
Stand right here, face the clerk, raise your right hand. Do you swear or affirm that the testimony about the case will be the truth, the whole truth, and nothing but the truth?
Yes. All right, you can be seated. You'll speak on a microphone in front of you. You can wait if you need to.
Good afternoon, Ms. Watson.
Afternoon.
So you completed an affidavit prior to the filing of the motion for new trial in this case. Is that correct?
Yes, ma'am.
And can you describe the interaction that, for the court, that you saw between Officer Bowen and Officer Butler after Officer Bowen's testimony?
Officer Bowen walked out of the courtroom and he walked over to Butler. They kind of stood face to face, talked for a minute, and then he kind of put his back to me and kind of was like leaning over and talking hushly, and kind of overheard only a little snippet of it, and all I heard was they asked me, and he like got down deeper into talking to Officer Butler.
Did their body language lead you to believe anything about their conversation?
That they were trying to hide it?
Okay. Now, when Officer Bowen left the courthouse, was Ms. Watkins outside?
Yes.
And was she the next person that you saw called in to testify?
Yes, as he walked out, she got up and walked in to come in and testify.
Now, did you see any interaction between Officer Bowen and Investigator Butler prior to Officer Bowen coming in to testify?
No, I did not.
Okay. Was Investigator Butler outside at that time before he testified?
Yes, he was.
Okay. Now, during the testimony of Ms. Watkins, where was Investigator Butler?
He was at the end of the hall by the windows.
Okay. Well, there are windows along the whole hallway. So was he by the courtroom or by the elevators?
By the elevators.
Okay. And did you see Ms. Watkins have any conversation after she left the courtroom for what you can only assume was her testimony? Did you see her have any conversation with Investigator Butler?
She walked past me, she walked all the way down to him, and she kind of was talking to him face to face. Her back was to me. And at one point, I did hear her say, did you know that? Kind of like a very strong question to Officer Butler.
Okay. Now, just to be clear, in all candor to the court, did you hear the rest of the content of their conversations?
No, ma'am, I did not.
Okay. And to your knowledge, were these conversations had prior to Investigator Butler being called to testify?
He had not been called to testify yet, no.
Okay. I have no further questions of the witness.
Thank you. To the state.
I think I just have one. About how far away were you sitting from Investigator Butler?
I was on the third bench, he was on the first bench.
So you were sitting on the third bench from the door to the inside of the courtroom?
Yes, and I was sitting on the side of the bench that was closest to the courtroom.
Okay.
And he was on the end of the first bench, so there was a little bit more than one bench.
He was one bench away from you?
Yes.
Okay. Any further?
Any redirect?
No, no redirect.
May Ms. Watson be released?
Yes.
Thank you, Ms. Watson.
Thank you.
Any other evidence from the...
No, Your Honor, that concludes the defense presentation on our motion for new trial.
Okay, to the state.
Judge, if I may, has the court had the benefit of my response? I think to save time, the only point we intend to elicit any testimony on is number 18 of defense's motion. That's under Florida Rule of Criminal Procedure 3.66B7. And if we could turn on the Zoom, I do believe Investigator Bowen should be there.
Who is Shane Fisher?
I have no idea, Judge.
Shane Fisher, what case are you on? Okay, I'll do that. Thank you. Okay, well, Fisher just disappeared.
Daniel Godwin, that's a totally separate case.
Okay. Mr. Godwin, we'll get your case in a few minutes, okay? So I'm gonna, I'll put you in the waiting room. Okay. Now, Ms. Bowen, her audio is not locked up yet.
Mr. Bowen? It's
Mr.
Nathaniel.
Bowen? Okay. Mr. Bowen's audio's not connected. There we go. Mr. Bowen, if you'll start your camera. Good. Thank you, sir. Mr. Bowen, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, we can't hear you, Mr. Bond, for some reason. It doesn't say your mic.
Can you hear me now?
We can, thank you, sir. And your answer to that
Yes.
was what?
Yes.
Thank you, sir. You can put your hand out, Ms. Bergman.
Investigator, can you introduce yourself, please?
You can pull that mic down if you want to. There you go.
Can you please
That
introduce
was
yourself?
Investigator Bowen with the Okaloosa County Sheriff's Office.
Did you testify in the state of Florida v. Jonathan Watson trial on July 23rd, 2024?
Yes, ma'am.
Did you have any contact with Kerry Watkins outside of the courtroom the day you testified?
I don't know who Kerry Watkins is.
Okay. Did you have any contact with Sergeant Butler outside of the courtroom on the day you testified in this trial?
Yes, ma'am.
Did you discuss your testimony with him?
No, ma'am.
Did he discuss his testimony with you?
No, ma'am.
What did you discuss?
We talked about things related to his position at the training center. We had a new sergeant come over recently. So we're talking about increased workload and dealing with cadets and stuff like that.
Okay. Do you recall where in the hallway this conversation took place?
If I'm remembering correctly, right outside the courtroom doors, there's a bench immediately to the left. And we were towards the end of that first bench on the left as you come out of the courtroom.
Okay. Thank you, investigator. I don't have anything further.
Yes, ma'am.
Ms. Powell, questions?
Yes. Investigator Bowen, did you, I'm going to move the microphone a little bit.
Yes, ma'am.
So we can hear. Investigator Bowen, did you see Investigator Butler prior to being called in to testify in this case?
Yes.
Were you talking to him before you came into the courtroom?
Yes.
And it's your testimony you were talking about the same things?
Yes, ma'am, the same type things, just related to work.
Okay, if they were work-related, why were you trying to hide your voice and speak in such a hushed tone?
Because we're in a court, and that's the generality. Whenever we're in a court, we kind of maintain a quiet and calm demeanor.
So when you left the courtroom and walked outside the doors at the end of the courtroom and additionally the other doors outside the vestibule, you still felt like you needed to whisper and speak very closely to Investigator Butler? Is that your testimony?
Generally, I don't talk loud whenever I'm in court or in the hallway or anything like that, so it's not abnormal.
Okay. And with regard to your testimony in this case, it's your testimony that that's not what you were talking to Investigator Butler about, right?
Excuse me, I don't understand. Can you say it again?
Well, when you said they asked me, as soon as you walked out of the courtroom, what were you talking about?
I don't recall saying they asked me.
Okay. I have no further questions, Judge.
Okay. May Investigator Bowen be released?
Yes, Judge, you can. Thank you, investigator.
Ms. Powell, be released?
Yes, Judge, sorry.
Thank you, sir. You're
Thank
released.
you for the accommodation. I really appreciate it. Thank you.
Thank you. State would call Kerry Watkins.
All right, stand right here. Raise your right hand. Do you swear do you swear or affirm that the testimony about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, please be seated. We'll speak in the microphone in front of you. You can move it if you need to.
Good afternoon.
Good afternoon.
Can you introduce yourself, please?
My name is Kerry Watkins.
Did you testify in the state of Florida v. Jonathan Watson trial on July 23rd, 2024?
Yes.
Did you have any contact with Investigator Bowen outside of the courtroom on the day you testified in this trial?
No.
Okay. Did you have any contact with Sergeant Butler outside of the courtroom on the day you testified in this trial?
Yes.
Did you discuss your testimony with him?
No.
What, did he discuss his testimony with you?
No.
What did you discuss?
I discussed just that I was surprised that this case was at trial because we had had text messages. And then I discussed what the family member of the defendant was glaring at me the whole time. So we talked about those two things.
Okay. Do you remember what Sergeant Butler's response was to anything of that nature?
No.
How long were you discussing, how long did you have a conversation with Sergeant Butler?
Not long. I was on my way out, and he's my coworker. I just kind of stopped and I talked with him a little bit, but just a couple minutes.
Okay. Do you remember where that conversation took place in the hallway?
At the end of the hallway.
The end closest to the courtroom?
No, the other end.
Okay, so over
Closest
by
to
the elevators? Okay. I don't think I have anything else for you.
Thank you. Ms. Powell?
Thank you. Good afternoon, Ms. Watkins.
Good afternoon.
When you were released from the courtroom after the testimony, you were subject to recall, correct?
I thought I was released.
Okay. Did you know that Investigator Butler had not yet given his testimony in this case?
No. I mean, I went before him, so yes, I guess I knew he hadn't gone yet.
Okay, so, but you did discuss this case with him as you were leaving the courthouse, correct?
Well, I discussed just in a general way that I was surprised that we were at trial for this case.
Okay, all right. Do you recall the specifics of your conversation?
I remember talking about text message, that we had text message.
Okay. You and he had text messages, or that there were text messages in this case?
There were text messages in the case.
Okay. And had you reviewed those text messages?
Pardon me?
Had you reviewed those text messages?
I knew they were brought up when we talked about the case when we very first started, but I hadn't reviewed them.
Okay. And do you know whether or not Investigator Butler was going to be questioned about any of those text messages or his involvement with those text messages?
I don't know.
Okay. I have nothing further, Your Honor.
Okay, any redirect?
No, Judge.
May Ms. Watkins be released?
Yes.
Yes, Judge.
Thank you, ma'am.
State would call Sergeant Butler.
Right here. Face the clerk, raise your right hand. Do you swear or affirm that the testimony about today will be the truth, the whole truth, and nothing but the truth? I do.
All right.
Good afternoon, Sergeant.
Good afternoon.
Can you please introduce yourself?
I'm sorry?
Can you please introduce yourself?
Yeah, Sergeant Jeffrey Butler with the Okaloosa County Sheriff's Office.
Did you testify in the state of Florida v. Jonathan Watson trial on July 23rd, 2024?
I did.
Did you have any contact with Carrie Watkins outside of the courtroom on the day you testified in this trial?
I did.
Did you discuss your testimony with her?
I did not.
Do you remember if she discussed what she was testifying to?
She did not. No, she did not.
What did you discuss?
Our conversation, from what I recall, and granted it's been probably about 2 months since then, but our conversation really was more about just kind of how she was doing. I think I asked her if she was still with the CAC at that time, since I used to work with her on cases 2 years prior to that. But there was nothing significant about that conversation.
Okay. Do you have any contact with Investigator Bowen outside of the courtroom the day you testified in this trial?
I did.
Did you discuss your testimony with him?
I did not.
Did he discuss his testimony with you?
No, ma'am.
What did you discuss?
So Investigator Bowen came, sat down next to me on the bench, and was asking me about my position and training since I had transferred over there. Specifically, I remember him asking me about how it was going with all the new trainees that we've put into field training and how busy the job was. That was the context of that conversation.
Okay. Thank you. I don't think I have anything else.
Ms. Powell?
Thank you. Sergeant Butler, during your conversation with Ms. Watkins, do you recall where you were standing for that conversation?
I believe it was down by the end of the hallway toward the bathroom
Okay.
area.
Okay. And during your conversation with her, it's your testimony that you guys did not discuss her testimony at all, correct?
That's correct.
But you knew you were being called as a witness in this case, right?
Sure.
And you are familiar with the rule of sequestration?
Yeah, I know we can't talk about anything regarding the trial. Yes, ma'am.
So with regard to your conversation with Officer Bowen, you stated that you guys were just talking about your new position as a training officer?
Correct.
Do you recall him stating to you, "They asked me"?
No, ma'am.
Beginning a sentence with that?
No, ma'am.
You don't recall that at all?
No, ma'am.
And where was your conversation with him?
On the bench out here.
And when you say the bench out here, just for
I believe it was,
purposes of the record?
Sure, I believe it was maybe the first or second bench outside of the courtroom on the
Okay.
left.
Okay. And it was outside the doors at the back of the courtroom, correct?
Correct.
And outside the doors, outside the vestibule, right outside the doors at the back of the courtroom, correct?
Yes, ma'am. Outside in that hallway.
Okay. And were you speaking in a normal tone of voice?
Yeah, I mean, probably low because court was in session, but yeah, we were just talking to each other.
Okay. No further questions, Judge.
Thank you. Redirect.
I don't have any. Thank you, Sergeant.
May Sergeant Butler be released.
Yes, Judge.
Thank you, sir. You're released.
Thanks, sir.
Any other evidence from the state?
No, Judge, just argument.
Okay. Ms. Powell, any rebuttal?
No, Your Honor.
Okay, argument, Ms. Powell? Any other argument?
Well, just rebuttal after the state.
Okay. Yes, ma'am. To the state.
Thank you, Judge. Florida Rule of Criminal Procedure 3.600B8 says the court shall grant a new trial only if the substantial rights of the defendant were prejudiced due to any consideration or due to any cause not owed to the defendant. Defense is alleging here he didn't receive a fair or impartial trial because they claim the witnesses violated the rules of sequestration. As we stated, we disagree with defense on what they believe occurred during the conversations in the hallway. Officers Bowen and Butler testified that they spoke as colleagues about personnel and other OCSO-related matters. Significantly, Investigator Bowen said he did not discuss his testimony with Sergeant Butler, and Sergeant Butler said that he did not discuss his testimony with Investigator Bowen. The second interaction is the defendant's wife allegedly heard Carrie Watkins and Officer Butler with Carrie saying, "Did you know that?" Carrie Watkins said she made a comment about text message trial. She said the text message in the case, because it was going to trial, stated she was aware of that because that had happened during the initial intake in the case back in 2022. She said she did not discuss her testimony with Sergeant Butler, and Butler said that he did not discuss his testimony with Carrie Watkins. These communications do not violate the rule of sequestration. The rule of sequestration, I apologize, it's hard to say. The rule of sequestration is for the content of testimony. The rule doesn't say you can't talk to witnesses at all, like the rule against speaking to jurors. It does state, at the request of a party, the court shall order, or upon its own motion, the court may order, witnesses excluded from a proceeding so that they cannot hear the testimony of other witnesses. And the witnesses told you today that they did not discuss their testimony with each other. So we don't believe that there was any error under that basis. However, to prevail, defense would still have to show that the substantial rights of the defendant were prejudiced, and we don't believe that's been established because there was not a violation of the rule of sequestration. They were also seeking a new trial under Criminal Rule of Procedure 3.66A2, which says the court shall grant a new trial only if the verdict is contrary to the weight of the evidence. And that's evaluated under the weight of the evidence standard, which is whether a greater amount of credible evidence supports an acquittal. Defense cited reasons in their motion. The state responded to each and articulated why the guilty verdict was not contrary to the weight of the evidence. And we would incorporate that by reference. We would also significantly note victim was a credible witness in this case. She testified at length about what had occurred on February 12th and February 14th. She was on the stand for several hours on the 23rd of July. She said that the defendant had penetrated her vagina with his fingers on both of those dates. Her mother, Belinda, had corroborated that the victim was over at the Watson home that evening of the 12th, and Crystal Watson corroborated the victim and the defendant were cuddling that evening and fell asleep together on the couch, which supports the victim's statements regarding where the first incident occurred. The defendant even said that he was cuddling with the victim that evening and fell asleep there. The victim's mother and Crystal Watson corroborated his access to the victim and the two being alone together on February 14th of 2022. The defendant admitted he drove up to Crestview alone that evening to take the victim to dinner. He admitted that he gave her jewelry from Zales and even stated that he couldn't consider that kiss not romantic on February 14th in the truck. That was about at 10:40 on July 24th during his examination. The text messages from the defendant's phone that were introduced as a joint exhibit corroborated his access to the victim on the 14th and the 12th because the nearly constant messages between the two ceased. They were also romantic and sexual in nature, and we referenced that in paragraph 2. There are references to what happened the other night within the messages. On February 13th, 2022, the day after the first incident, the victim texted the defendant saying, "Last night felt great, but I can't help feel a little guilty." That's at page 652. When the victim was questioned about that statement at trial, she said she was referencing the defendant touching her on February 12th, 2022. And on February 14th, February of 2022, at 6:65, the defendant says, "Do you have any idea how much I want you?" and asks what the victim is thinking about. She responds, "Well, it's been mostly the other night." When the defendant asks her to explain, she says, "On how good it felt to be with you, how good to feel your hands on my body." The defendant then responds, "It feels good to be with you and your body is amazing." We went through each of defense's claims as to why they don't believe the verdict supports the weight of the evidence in this case. However, we do believe the greater weight of the evidence does support the guilty verdict in this case. To save time, we won't go through each of those that we already referenced in our motion. They're also seeking a new trial under Criminal Rule of Procedure 3.600B6, which says the court shall grant a new trial if the substantial rights of the defendant were prejudiced because the court erred in any decision of any matter of law arising as a matter of course in trial. He says his rights were prejudiced due to the court's ruling on the motion in limine to exclude the introduction of the male DNA that was in the crotch of the victim's underwear on February 14th, 2022. First, defense must demonstrate that the substantial rights of the defendant were prejudiced by the exclusion of the DNA, and they did not do that in this case. Second, the court did not err in granting the state's motion in limine, and therefore there isn't an error or decision as a matter of law upon which to grant a new trial under B6 either. The defendant's rights were not violated under the Confrontation Clause. That is a fact-specific analysis, and defense had cited Lewis. In Lewis, defense wanted to bring testimony in regarding the alleged victim's prior sexual activity with her boyfriend that was protected under the Rape Shield Law. In that case, the defendant was the stepfather of the victim. The victim was sexually active with her boyfriend, and the mother and father suspected it, but she had denied it. The victim was apparently concerned that the gynecologist would discover and tell her mother was sexually active because she had an appointment 7 days before she made the charges against the stepfather. Under those facts, Lewis found that the Rape Shield Law was overcome when it interfered with the defendant's confrontation rights. The facts in our case are distinguishable from those. First of all, Lewis involved testimony about the victim's prior sexual activity. The state specifically sought to exclude reference to third-party DNA from the victim's underwear in our motion in limine. If defense wanted to flesh out a specific defense or admit testimony regarding the victim's prior activity, they should have filed a motion to do so. We did state there weren't the particulars given as to what exactly they wanted to introduce. The state had filed their motion to specifically exclude the DNA in the underwear. At the motion hearing, state had cited Esteban v. State, which said the court requires proof of a specific motive to fabricate before overruling a Rape Shield Law. Without any specific proof, then the Rape Shield Law would have little effect, because a defendant could always argue that prior sexual conduct or reputation was a reason to lie about subsequent activity. That's 967 Southern 2nd, 1095 at 1099. Again, Our case differs from Lewis in another way because LGK's disclosure doesn't show any sort of motive or intent to fabricate these allegations. She only disclosed what happened with Jonathan Watson after her mother got an anonymous message and confronted her. She did not come forward on her own without prompting. Lastly, third-party sperm cell DNA evidence in a victim's underwear is not relevant to the charges because it could not prove that someone else digitally penetrated her vagina on 2 occasions. And defense was allowed to elicit testimony regarding the fact that no DNA came back as belonging to the defendant at trial. So we don't believe that his confrontation rights were violated. We do believe the exclusion of the sperm evidence was a proper ruling, and therefore there is no basis to grant a new trial under B6. Lastly, defense is seeking a new trial under Criminal Procedure Rule 3.600B7, which says the court shall grant a new trial only if the substantial rights of the defendant were prejudiced because the court erroneously instructed the jury on a matter of law. Defense claims this was due to the court's answer to the jury's question asking to see the CPT interview. The court had proposed telling the jury that the judge was not able to provide the victim's testimony from the Child Protective Facility because it was not entered into evidence. That's correct. It was not entered by the state into evidence. Both the state and defense agreed to the answer to that question going back to the jury. So state would argue under the fundamental rules of fairness, defense had waived that argument as there was no objection to it at the time. You can't agree at the time and then later come back and say it's a basis for a new trial. However, regardless, it's not an error because it's not an erroneous instruction as a matter of law. Therefore, we don't believe there's a sufficient basis to show that the substantial rights of the defendant were prejudiced under B7 either. And as far as what the jury believed by asking that question or what they thought when they got the court's response, that's pure conjecture. So for those reasons and the reasons we outlined in our motion, we believe that any alleged error was harmless and the state does not believe there's any basis to grant a new trial.
Thank you. Ms. Powell, finally.
Yes, Your Honor, just a brief rebuttal as to some of the allegations or assertions in the state's response that were incorporated by reference into her argument here in court today. One of the issues that the state admits in their motion, or their response to the motion, is that the victim testified she was close to Ember, but she told Mr. Watson, the testimony came out during trial, that she told Mr. Watson, she told Ember the truth about what had happened. But she admitted that she only told Ember that they had kissed and then they mostly talked about the incident that had occurred on February 14th in the vehicle. The state says that the victim felt shame and guilt over what was happened and was afraid Ember would not forgive her. But it doesn't make sense, Judge, that she would tell her about a kiss but not tell her about something else. If anything, she would have, if she felt shame and was afraid Ember would be upset with her, she wouldn't have told her about the kiss. So it's our position that she did tell Ember the truth, and it was just a kiss in the vehicle that night. Additionally, Your Honor, a review of the messages that the state references on page 652, where the victim texted the defendant saying, "Last night felt great, but I can't help but feel a little guilty." Again, Your Honor, I would encourage you to look at the text messages surrounding that. The text messages that the state is relying upon in their motion are handpicked. I would direct your attention to the conversations that the victim and the defendant had after February 14th, after he dropped her back off at home. One of those messages was she told him, "I feel safe with you," which is not consistent with what her testimony was at all, Judge. Additionally, with respect to, I think I covered some of these, I just want to make sure, Judge. The state did argue that the text messages between the alleged victim and my client, Mr. Watson, at or near the time of the offenses were romantic and sexual in nature, and we disagree with that characterization. Certainly there were some romantic type of texts. There was nothing sexual in those texts. There were no admissions. Again, Your Honor, And even when Mr. Watson asked the alleged victim in this case, what do you feel guilty about? She doesn't say the way you touched me or what happened between us the other night. She doesn't say that. The absence of that is very telling, Your Honor. At no point in time does she even volunteer during those text messages that anything more than a kiss ever happened, and she doesn't even talk about that. Your Honor, we believe that the weight of the evidence favors a verdict of not guilty. We are asking you to sit as the seventh juror in this case and to overturn the verdict that was returned in this matter and grant us a new trial. Thank you.
Mr. Watson, the first time I've ever heard, well, read about the seventh juror was in Ms. Powell's motion for new trial. And I, stared at that a long time. Very interesting for the court to be in that role. Ms. Powell argued here orally, because I look for, and the attorneys have heard me use the term buzzwords. What does the court have to find to rule for or against a motion? And I know the key ones that both sides have argued, but in Ms. Powell's argument, I was trying to figure out what, contrary to the law or the weight of the evidence, and the weight of the evidence is what the court has to look at. And I agree with Ms. Powell that that's it. I was trying to figure out how does the court define that? How's that characterized? And Ms. Powell used words like that what the state put on was not credible, not consistent testimony, easily could find was one term she used. It doesn't make sense, I think, was what was used in her rebuttal argument. What I like about being the judge during the trial is that I hear all the evidence. Sometimes defendants will plead straight up, and then I have to sentence somebody by what I hear leading up to that sentence. Totally different when I sit through the whole trial. I only consider what comes into evidence. I don't consider any motions in limine that were granted. Anything that the jury didn't hear, I don't consider that. And I've got a whole legal pad of notes that I took the days of your trial. The court finds, and I'll flesh this out more in writing, but that the substantial rights of Mr. Watson were not violated in any of the four regards. It certainly concerns me as far as the rule of sequestration. When I see that, when I read the affidavit and the two portions of the sentences, I wanted to hear what the witnesses testified to. But as much as hearing what the testimony was, I had to find that somehow the violation of that rule prejudiced you. And I don't have that here. I don't have testimony that says Ms. Watkins testified in a deposition this and then changed her testimony, or that any of the other witnesses had an affidavit that they said one thing and they came into the stand and testified to something different, and then the court could attribute that to what was stated in the hall. So I can't find that. There apparently were discussions regarding text messages, or at least a reference to that. So I can't say the rule of sequestration was not violated, but I can't find any prejudice to you because of that violation. So respectfully, the motion for new trial is denied. So the court will prepare an order. Again, I'll put more substance in that order than I stated orally. We'll take a 10-minute recess, and then we'll come back and do the other cases.
Thank you, Your Honor. We
Thank you, Ms.
appreciate your
Powell.
time this afternoon.
Yes, ma'am. Thank you.
All rise, please.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm Attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take one.
Have you been?